Good morning, everybody. Thanks for joining us today. My name is Brett Peterson. I'm the market president for Bloomington Normal for Busey Bank. Again, I know many of you, but if I haven't met you before, thanks for joining us this morning. A few housekeeping items. Again, we are recording this call, so this will be available. I'll introduce Renee here in a second, but we have myself on the call. We have Matt Lage, who's monitoring the chat. So if you have any questions, please type those into the chat. We're going to hold those till the end so Renee can address those. I also believe Taylor Morgan's on the call this morning. I think he's dialed in, but if there's any advisor side questions, we can help answer those as well. But again, yeah, thanks for joining us. It's a nice day here in Bloomington, so we'll go ahead and get started. Renee's presented to this group before in the past, but so Renea Harbert is our Chief Fiduciary Officer for the bank. Renee's been with the bank for 6 years now, and Renee, I'm going to date you a little bit. I think you've been in the industry for almost 30. Is that right?
Yeah, that is correct.
Before her current role, Renee served as our Director of Estate Settlements, so helped us through all what I would consider some of our more complex cases and working with our clients directly. And again, appreciative to have her here today. She has a JD and a Master's of Law in Taxation, and honestly has been a great resource for my team here, just speaking independently of this. But to put together this presentation, walk through all these different important items that we face on a day-to-day basis when talking about estates and wealth management and really your overall financial well-being. So with that, Renee, I'm gonna let you take it from here and kind of walk the presentation. And again, for the group, please type any questions that you have, and we'll make sure to address those at the end of the presentation. So thank you.
Great. Thanks, Brett. Good morning, everyone. Really appreciate all of you spending part of your morning here with us. And today I'm planning on talking about estate planning, what it is, why it's important, and how thoughtful planning can help protect both your assets and the people you care about the most. As Brett mentioned, I have spent the past 30 years working very closely with families, attorneys, accountants, beneficiaries in the administration of estates and trusts, and do have a legal and tax background that's come to bear on a lot of those administrations as well. And over all of those years, I've seen a lot of things that work really well, and unfortunately, a lot of things that do not. I've seen situations where good planning made things much easier for families during a very difficult time, and also seen cases where a lack of planning has caused lots of unnecessary stress, delays, and a lot of family conflict that's then resulted in, unfortunate litigation. So I think one of the things I can say with certainty is this from those years of experience is that having a well thought out and up-to-date estate plan can really minimize a lot of the bad stuff. And I think too, going into the estate planning process with a willingness to have conversations about your estate plan with your loved ones can also manage family expectations and really help to reduce emotional stress for the family down the road, and hopefully make sure that your family isn't one of those that are getting into those litigious situations later on down the road. And then before we dive in here to more of the presentation, I do need to cover a very standard but a very important disclosure that today's discussion is meant to provide general information only. It is not meant to be to provide legal or tax advice. So estate planning decisions really should be made with your attorney or tax advisor based on your specific situation. And so my goal today is really to hopefully, leave you feeling a little bit more informed, more confident, and better prepared to have conversations with your legal advisors when that time is right for you. So let's start with a statistic that surprises, I think, a lot of people. Studies have come out that about 70% of Americans either don't have an estate plan or they haven't updated their estate plan in a number of years. And so really, why does estate planning matter? And I think at its core, estate planning is really about control. It's control over who makes decisions for you, control over who receives your assets, and control over how much stress you're leaving behind for your family by either making or not making an estate plan. And just as important as creating an estate plan is making sure that you're reviewing that on a regular basis. Life is continually happening. Marriages occur, there's divorces, there's deaths. Maybe you have new grandchildren being born. There's changes in, the assets that you might hold and the value of those assets. And there is often changes in tax laws. And really, your estate plan should change along with your life. I'm very fond of saying that an outdated estate plan can be almost as problematic as having no plan at all. So it's very, very easy to go ahead and say, hey, set it, forget it. I've got it all taken care of. But that really can lead to unintended and sometimes painful results. For example, I've seen situations where grandchildren were unintentionally disinherited simply because a plan wasn't updated to include children born after the documents were created. Another example, particularly relevant to us living here in Illinois, is that Illinois has a separate state estate tax exemption that kicks in when you have assets that you own that exceed $4 million. That is much, much lower than the current federal estate tax exemption of $15 million. So if you have documents that were created decades ago, and over time your wealth has increased and you potentially could be at or over that amount, your documents may not include some tax efficient planning strategies that could dramatically reduce your state estate taxes later on at the time of your death. And that would include things such as making sure that your document is allowing for use of the marital deduction at the first spouse's passing, which will allow for there not to have to be any estate tax owed at the first spouse's death. And that could have been avoided potentially if you had updated maybe a prior estate plan document. So I really do recommend that even if you do have an estate plan, don't just set it and forget it. Make sure that you're reviewing those plans at least every 2 to 5 years, and especially anytime there may be a major life event that could have impacted what you might have included in that plan. So as mentioned, really at the heart of estate planning, I think, is control. You decide who gets your assets, when they get them, and under what conditions. And if you do not put a plan in place, guess what? The state is going to decide for you what happens to your assets, who gets them, and under what conditions. Not usually what you intend to be the outcome. So, and those are going to cause a lot of not having an estate plan in place or not updating it on a regular basis could potentially, create those unexpected outcomes. And unfortunately, the family conflicts that I mentioned that could lead to litigation for your family that you did not necessarily want to have occur. So I'll share with you a real life example here of a situation where an individual did not plan accordingly. So we are currently serving as a court-appointed administrator of a multi-million-dollar estate for someone who passed away without a will. This individual had given up her twin daughters for adoption at the time of their birth, and she later reconnected with her biological children, but Illinois law doesn't allow adopted children to inherit through their biological parent, absent specifically naming them to inherit in the biological parent's estate documents. So this individual did name their daughters as beneficiary of their IRA, but didn't take any other planning action. And as a result of that, her assets are now going to go where she likely did not intend them to go. And instead, they're going to be dispersed to very distant cousins who this individual had no knowledge of and had never met. So just a real life example there of what can happen if you don't take the time to, plan accordingly. Some other examples of what could happen by not having an estate plan, possibly a surviving spouse may not receive everything that you assume that they would upon your death. Family members could end up in legal disputes. You could lose opportunities to reduce estate taxes. You could also lose the ability to protect beneficiaries who may need some added safeguards, such as being able to maybe set up a trust for a special needs beneficiary, or for somebody who is struggling with addiction, or somebody that is not able to handle finances appropriately. So it really is important to have those estate plans in place because it allows you, not the state, to make those decisions and not have these potential unintended or unexpected results. Estate planning forces us to answer, I think, some important and oftentimes sometimes uncomfortable questions, but you're asking things like, who's going to inherit my assets and when? Who manages things if I'm incapacitated? Who do I trust to carry out my wishes if I'm not able to? How do I protect minors or other vulnerable beneficiaries? What happens if I might have a business or farmland at the time of my death? And how do I build into my plan some flexibility if my circumstances continue to change? So, and also I think a big question that is often overlooked as part of estate planning is asking yourself, who is the right person to serve in key roles within your estate plan? Who are you going to name as executor under your will, as trustee of your trust, as guardian of minors or special needs children, to serve as your power of attorney for financial matters, or for healthcare? We'll spend a little bit more time on that a little later here, because those decisions matter just as much as the creation of the estate plan documents themselves. So I'm going to go into a little bit about some of the core estate planning documents that you should consider putting in place for yourself if you don't already have them, or also if you don't, or making sure that you are looking at updating these documents if you do happen to have them in place. So estate planning doesn't revolve just around a single document. It's really a set of documents that should work together. And these documents will usually include a last will and testament, maybe one or more trusts, a power of attorney for financial and medical decisions, and an advance directive. And each one of these documents can serve a different purpose. The key here is really coordination. You want to make sure that all of these documents are aligning with your goals and that they're all working together the way that they should. So I'm going to walk through some fundamentals of each one of these documents. The first one is the last will and testament. A will is really sort of the foundation of most estate plans. Your will is what's going to control assets that are titled in your individual name. It's going to name who you want to serve as executor. It will direct how your debts and taxes are going to be paid upon your death. And it will also outline who is going to receive, your assets held in your estate at the time of your death. It's also the place where you nominate guardians for minor children or for special needs beneficiaries. A couple things to note about wills is that a will only becomes effective when you pass away. It has no impact whatsoever during your lifetime. It's only going to impact those assets that you hold as of the date of your death that are titled in your individual name. And those assets also must go through probate, which will cause that document and those assets to be part of the public record. So that means that I could go into a court and look up anybody's will that has been filed and determine who's going to get what, and exactly what does that document say. That is one of the main reasons that a lot of people will look to trust, because trusts are private documents and are not subject to public inspection. Only the beneficiaries or the interested parties to that trust are the ones entitled to receive information relating to the terms of that document and to the assets that are held by that trust. And trusts also have the ability to address better incapacity planning, some specific planning goals, and also kind of allows things to move a bit more smoothly and quickly than does assets that have to go through probate. So moving on to trust. Trusts are some of the most flexible and I think powerful tools in the estate planning arsenal. There's revocable trusts. These trusts will allow you to stay in control of any assets that you title in the name of that trust during your lifetime. And that means that at any time you can change any of the terms of that trust, you can revoke it, you have total control. It's just that you get some of those other benefits that we talked about that you don't get if you only have a last will and testament. Like I said, it can help avoid probate. It provides privacy. It also allows a successor trustee to step in very seamlessly if you become incapacitated or die. You don't have to go to court to get somebody to step in when that happens. Trusts also provide some additional safeguards as the trustees that you've named in the document. They're going to be bound by fiduciary duties, and that's going to create a lot of accountability and protection for your beneficiaries. Revocable trust will become irrevocable upon the death of the creator, and at that point in time, that trust will continue to govern the management of any assets that you have put in the name of your trust. And then the terms of that trust document are going to define who receives your assets, how they're going to be used, and when distributions are going to be made. And that's all according to your instructions. So a trust could provide outright distributions It could, provide that the trust will continue for the benefit of beneficiaries. And this can offer a lot of flexibility to address a variety of planning goals that you might have. One example of that would be if you're part of a blended family, your trust upon your death could state that it will continue for the lifetime of your surviving spouse. And then at their death, that trust will then benefit your children rather than those assets being designated by your spouse to go somewhere other than where you would have delegated them to if those assets had been distributed outright to her. So it is a way. I've heard a lot of people maybe tell you that it's a way for you to control things from the grave, right? So trusts are a great way to be able to make sure that your wishes are upheld even when you are no longer around to make sure that those things are being done. Trusts also can be used for generational planning. This allows assets to continue for multiple generations. So if you want to leave a lasting legacy that lasts in perpetuity, you can do so. That trust can continue for the lifetime of your children, your grandchildren, your great-grandchildren, your great-great-grandchildren. You can really make it last as long as you want, as long as assets still remain within that trust. And another benefit of that is that while those assets remain in trust, a lot of times they also continue to protect those assets from the creditors of your beneficiary, maybe a divorce that might occur, or some other risk that a beneficiary may be exposed to. So it can have some nice asset protection benefits as well by keeping trust going on for multiple generations. So I think the thought is here that trust, why they are so powerful is that you really can do just about anything with a trust, and it's really only limited for the most part by public policy. So as long as it doesn't run afoul of public policy, you can pretty much do just about anything you want with a trust. And irrevocable trust can also be established during your lifetime. They don't just have to become irrevocable at your death. And these type of trusts are most commonly used for tax planning, maybe asset protection, eligibility planning. But because these trusts generally cannot be modified once they are created, they do require some very careful and thoughtful consideration to make sure that they will be appropriate for your particular situation and something that makes sense for you to include within your estate planning documents. Some examples of some of those trusts would be maybe a trust that you establish for grandchildren in order to fund their education. Another common example could be a special needs trust, which would allow assets to be set aside for a child with special needs. That will also then preserve that beneficiary's eligibility to obtain governmental benefits. And then irrevocable trusts are also frequently used for estate tax planning situations involving highly appreciating assets. So if you transfer a highly appreciating asset into an irrevocable trust, so in essence, you're gifting it to that trust, the value of that asset that you gifted into the trust effectively freezes the value of that asset for estate tax purposes as of the date of the gift to the trust. So that allows future appreciation on that asset to basically escape a estate tax situation in the future. I think the bottom line here is that trusts can accomplish a great deal, but just note that in order for them to really reach their full potential, you need to make sure that they're properly structured, that once they are created, that they actually get funded, and that you have the right people in place to administer them. Moving on to beneficiary designations and titling of assets. This is one of the most commonly overlooked aspects of, let's move sorry about that, of estate planning is beneficiary designations. This is often where well-intentioned plans break down. Certain assets, specifically retirement accounts like your IRA and life insurance, will typically pass by a beneficiary designation. This means then that those assets are not controlled by the terms of your will or your trust unless you specifically name your will or trust as the beneficiary on that beneficiary designation form that you're asked to complete. But I do caution that you need to make very careful consideration of who is the appropriate beneficiary to name for those type of assets. If you guys are familiar or heard of the Secure Act that was enacted back in 2020, it significantly changed the rules governing inherited retirement accounts. So with limited exceptions for surviving spouses and other special beneficiaries, most beneficiaries of an inherited IRA are now required to withdraw IRA assets within 10 years of the owner's death. And if an IRA is payable to the owner's estate, that distribution period is further shortened to 5 years. In addition, naming a trust as beneficiary may not always be advantageous due to some potential higher income tax rates if distributions are retained within the trust. So you want to be very careful when thinking about naming a will, an estate, or a trust as the beneficiary of an IRA. It's also important to understand that assets that you hold in joint tenancy with somebody else, or that you may have put a payable on death designation on, pass outside the terms of your will or trust as well. And as a result, any beneficiary designation and also any and all asset titling of all of your assets should be reviewed periodically. And whenever you have a major life event, maybe a marriage, a divorce, birth of a child or a grandchild, just to make sure that all of those beneficiary designations are appropriate and that they have been coordinated with your overall estate plan. I've seen many outdated beneficiary designations, and those are one of the most frequent causes of unintended outcomes that I encounter. I've seen cases where a former spouse remained named as an IRA beneficiary long after a divorce. I've seen where a child may have predeceased an account owner, and then the beneficiary designation was never changed, and it didn't provide for that child's share to go to that deceased child's children, which then resulted in grandchildren being unintentionally excluded. And then finally, in reviewing beneficiary designations, I think it's critical to make sure that you're looking whether you have named contingent beneficiaries in the event that a primary beneficiary might predecease you or they might disclaim their interest in that asset. That just makes sure that assets are indeed passing according to your wishes rather than possibly defaulting to your estate. Moving on to advanced directives. These are sometimes called living wills. This document basically provides your wishes for end-of-life medical care. It's going to provide the guidance to physicians and loved ones during what's normally a very difficult time, and it helps reduce uncertainty about your wishes, specifically as it relates to removal of life-sustaining devices. And I think it serves to be very helpful in minimizing conflict between family members who may have differing opinions on how to proceed if that situation would arise. This is also the document where matters such as pain management and organ donation preferences can be addressed. These are very, very personal decisions, and having them documented really does matter. It provides clarity to your family on what you want to have done if something like that would occur. It reduces guilt for loved ones that are having to make those type of decisions. And then it does also ensure that whatever decisions are taken reflect your values and your wishes rather than having decisions based on mere assumptions. Oop. Too far. Powers of attorney. These are documents that allow someone to act on your behalf if you can't. They're very, very powerful. A financial power of attorney handles things like paying bills and managing accounts, where a medical power of attorney is going to make healthcare decisions for you if you're unable. The most important takeaway I can give you here is when you are putting these type of documents in place, that you are choosing someone that you trust completely, and then to also name backups that you also trust completely if your first choice is unable to serve in that role. As I mentioned earlier, trust can be used for incapacity planning. Financial power of attorneys are also a source for incapacity planning, but a power of attorney often grants the individual a very, very broad authority over your accounts. And that authority can create a lot of risk. And that's sometimes through intentional misconduct or unintentional misuse. For that reason, it is very critical to name someone who fully understands their responsibility and their duty to act solely in your best interest. Because once a power of attorney is put in place and becomes effective, the individual that is serving in that role basically can do everything that you can do unless you have specifically limited them within that power of attorney document to not be able to do that. So again, very, very critical to make sure that that is somebody that is trustworthy and will be only taking actions that are in your best interest. By contrast, placing assets in a trust provides some meaningful guardrails when it comes to incapacity planning. Trustees are bound by fiduciary duties, and that there's other mechanisms in place to monitor the actions of trustees and have them removed if for some reason they breach their duties of trust. This level of oversight and accountability really doesn't exist to the same extent with a power of attorney, which can sometimes be very difficult to revoke or remove once it is in effect. That's why it's good to think about combining the use of a power of attorney with trust, as it can provide some very valuable safeguards for you and your family if for some reason you need to have somebody step in because you have been deemed incapacitated. Equally important is careful consideration of who you appoint as your medical power of attorney. When selecting someone in that role, I think it's essential that you understand what your wishes are regarding medical care, and that you talk with the person that you want to fill that role for you, and make sure that they're willing to make the same decisions that you would make for yourself if you were able to do so. I have seen situations where, somebody is totally opposed to a particular procedure, and they will refuse to allow that procedure to occur, where the individual, had they been able to give their consent, would have had that procedure done. So you want to make sure that you and your medical power of attorney are aligned with what your medical wishes are. So that is the kind of a discussion of the core. Oops. There you go. Always good with the technology here. Can everybody still see that?
Yep, I can see it, Renee. Yep.
Okay. These are the core documents that you should be considering when taking a look at your estate plan, whether it's creating a new one or updating your plan. And just know estate planning is a process, and it's never too late to start a plan, and it's never too late to update your plan. On this slide here, I've tried to outline several items you want to consider as you prepare to meet with your attorney to either create or update your estate plan. And I think taking time to think through these topics in advance of meeting with your attorney can really help make that meeting more productive and efficient. And the top one here for me is really define what your goals are. Is it to make sure that your surviving spouse is taken care of? Is it to make sure that grandchildren education is paid for? Do you want to make sure that you're supporting charitable causes? Are you interested in making sure that you have a legacy that's going to span across multiple generations? Is your concern with minimizing federal or state taxes? That's just a few things, and it could be, you could have, these goals are not mutually exclusive, right? It could be you're concerned about all of these, or maybe you're concerned about one or two of them. It's really trying to define what your goals are and what your top priorities are, and making sure your estate plan does what you are wanting it to do. It's also important to make sure that you have taken an inventory of all your assets and how they are entitled, or how they're titled. This also includes like digital assets, if you have any cryptocurrency or anything that might be considered a digital asset. And then to make sure that you're reviewing those beneficiary designations so that when you do put your estate plan in place, you're understanding what documents are going to be applicable to those assets and how they will ultimately be distributed at the time of your passing. You also want to make sure that you're considering who you want to receive your assets. That could be individuals, it could be charities, could be both. In what proportions you want them to receive assets. Sometimes people just want to give somebody a specific bequest. Maybe that's a specific dollar amount, like $50,000. Maybe it's a specific asset, like 100 shares of AT&T or the vacation home in Florida. Or it could be a percentage of the entire estate. And that can be in equal proportions or it can be in unequal proportions. It's really based on what your particular goals are and your particular situation is. And it's thinking about what timeline do you want assets to be distributed to your beneficiaries. This could mean that at your death, you want assets to be distributed immediately outright to the beneficiaries, which then they have total control of what they then do with those assets. Or you could set some parameters around timing of their receipt of those assets, where you can have the assets remain in trust for their lifetime, which they will be able to access income and principal during their lifetime, but it's at the discretion of a trustee. Or you can also set some time limits on there too, to say, well, when my child reaches the age of 35, I want them to get a third of the value of the trust that I've created for them. And when they turn 45, they get a half. And then when they turn 60, they can have full access to all of the assets. So there's a number of different things that you can do there, but it's really trying to figure out what things are you concerned about, and whether setting some parameters around when they receive assets might be appropriate as you develop and create your estate plan. If first, you happen to own a business or farmland, really need to be thinking through how ownership and control of those assets are going to transition at the time of your death. Sometimes children do not want to remain in business together or own farmland together. Here's another real life example. I had a situation that involved approximately 600 acres of farmland that was held in a partnership, with that partnership interest held in trust. And at the death of the creator of that trust, that partnership was to distribute to his 5 children. Unfortunately, the operating agreement for that partnership did not contain provisions on how a child could get out of the partnership or how that interest would be valued. And as you can imagine, all 5 of those children were not on the same page with what they wanted to see happen. Some wanted to keep the farmland, some wanted to get out and be able to use those funds to invest in other types of investments. So as a result of this somewhat poor planning, this trust wasn't able to be closed for over 20 years. And we spent hundreds of thousands of dollars in attorney fees until that partnership could be dissolved and over 400 deeds were recorded to be able to get certain pieces of land in place that could be retained by some of the beneficiaries and then be sold by the others that wanted to get out. And the father of these children, in creating that partnership, had been very hopeful that it would basically force his children to get along and work together in managing this farmland. But it definitely backfired big time. And by him not having a clear understanding, excuse me, of really what each of his child's interests were in holding this farmland, it ended up resulting in irreparable harm to the relationship of the siblings and significant cost to the trust. So it's really important to kind of think through what may happen at the time of your passing if you hold on to these type of assets. And even though you may have a certain wish or desire of what might happen, it's always good to have some conversations with those that may be receiving these assets to make sure that proper planning is put in place to make sure that these type of unintended consequences don't result in your situation. I think it's always good too to make sure that you're clearly defining what your wishes are regarding your medical care and determining who you think is best to then serve as your healthcare power of attorney in making sure that those wishes are fulfilled. And then again, make sure you have a backup if your original person is unable to fulfill that role. And as I think I've mentioned before, it's very important before naming this individual in that healthcare power of attorney that you've discussed with them their desire to serve in this role and that they are indeed willing to make the decisions that you expect them to make. And this is similar as well to the people that you are wanting to name as executor, trustee, guardian, or a financial power of attorney. You really need to be evaluating whether those individuals have the time, the expertise, and the ability to handle the responsibilities that come with those roles. And again, make sure that you're thinking about who the alternates would be if your initial choice is unable to serve in those roles. If you have created prior estate planning documents, make sure that you're reviewing and bringing those along to any meeting with your attorney so that those can be considered in your updating of your estate plan. And then finally, I recommend to you to consider having conversations with your family to help set expectations and reduce surprises that sometimes accompany estate planning. This is particularly important when assets may not be distributed equally, or maybe you're going to consider putting assets in trust so that your family really does understand your reasons for these decisions. Doing a little preparation upfront can really make the estate planning process be a lot smoother and more efficient. How can Busey help you with the estate planning process? At Busey, we often serve as a resource through the estate planning process. We can help coordinate conversations with your attorney, conversations with your family. We can answer questions, and we can be a support to you your family, your advisors throughout the entire estate planning process. Additionally, we are also able to serve as trustee or executor, providing a professional, impartial administration of your trust or estate, if that would make sense within your situation. Because selecting the right executor or trustee really is an important choice. The role is far more complex than most people think. The role of an executor or trustee require that person to navigate legal and fiduciary obligations, to make sure that tax filings are completed, prudent investment management is done, that accountings are provided to the beneficiaries, that deadlines are met relating to the trust and estate administration, and then ensuring that communication is being done with beneficiaries to set expectations. And this is all while that individual, before serving in that role, is carrying personal liability for any mistakes that they possibly might make. And family members often underestimate, I think, both the time commitment and sometimes the emotional burden that comes with serving in these positions. So I think it is worth considering as you create or update your estate plan, whether a corporate trustee is an option for you. A corporate trustee can bring experience, resources, and infrastructure that's necessary to make sure that an estate or trust is administered accurately and timely. A corporate trustee can ensure compliance with trust, probate, and tax laws, prudent investment management, and impartial treatment of beneficiaries. Unlike an individual, a corporate trustee doesn't become incapacitated, doesn't relocate, doesn't pass away, and really can provide that continuity and stability for the family, particularly in those long-term or complex situations. And having an objective professional fiduciary in this role can also help preserve family relationships. Naming a family member often feels like an honor and an expression of trust, but it can unintentionally create tension if other beneficiaries perceive favoritism or question how assets are being managed. So engaging a corporate fiduciary can definitely help reduce those type of conflicts and allows families to really focus on their relationships rather than the administration of those trusts or estates. And then before we wrap up here and see if there's any questions, I did want to mention an organizational tool that we offer called A Message to My Loved Ones. It's a simple but a very powerful way to document some important information about your wishes and can create a roadmap for your family down the road when they may need it most. So I think, Matt, if there's some time here, I think we have some time left here. If there's any questions, I'm happy to see if I can answer those.
Yeah, I would say one quick comment too on the Message to My Loved Ones. So that's a document that we'd be happy to send you all, whether it be happy to mail you a hard copy of it or send over an email version of it as well to you. So if you just want to email one of the team members here or at goldtimers@busey.com, we'd be happy to send that over. We've passed this out in years past, but again, to Renee's point, it's a nice document to start to organize and start to thinking about all the things she's already mentioned as well. So just making that note.
Yeah, so there was an initial question that I think we went over. Renee just asked about, with an estate plan, a legal document like a will, and I know you kind of already went into that. So the next one that I'll come to here: what are the advantages and disadvantages of transfer on death on your house title?
I'm sorry, got a little trouble understanding there. What is the advantages or disadvantages on a transfer on death?
On your house title and car title.
On your house title and car title?
Mm-hmm.
I guess in those situations, some of the advantages, of course, putting a transfer on death will definitely avoid probate. Though disadvantage is that potentially if that individual that you named as the person to receive that property has died and it hasn't been changed, then that property will then flow back into your estate and be subject to the terms of your will, which potentially could have those assets going somewhere that you didn't intend them to go.
And then the other question that we had, and I think you did kind of touch on this, but essentially the question was, related to probate as in regard to assigned beneficiaries. Someone stated that they have a will and have beneficiaries assigned on each asset that they own. Just confirming that would be sufficient to avoid probate.
It can be, again, I think it's going back to that transfer, as long as the person that is named on there has not, is still living at the time that transfer is to occur. Otherwise, that will is a good thing to still have because, in essence, it's going to pick up, that asset and then distribute it to wherever you have designated, under the will. So, but as long as if you have those designations on all of your assets, it will avoid probate as long as the individual designated is still living at the time of the original owner's death.
Those are the only questions that we have. So I'd say too, if anybody has any additional questions afterwards, we can reach out to that goldtimers@busey.com email. Send those that way, and we'll get an answer to you. We'll involve Renee if any of that needs to be done as well. But those are the questions from the chat.
Okay, great.
Okay. Well, Renee, thanks for joining us. Thanks for presenting. Again, a lot of really good information. Again, if the group has any more questions and would like to follow up on something, please email us independently, reach out to us, call us. Happy to kind of sort through that and help in any way that we can. This recording will be available. I'd say give us a week or two to kind of clean it up. But this will be available, and we'll make sure the committee at the Goldtimers Group is aware of that as well. So with that, we'll go ahead and end the call. Again, thanks everyone for joining us. I hope everyone has a great rest of your day. Okay.